Do you even know who Chase Mulligan is? You're so obsessed with, you don't, do you?
I'm going to teach you the rules again. You're the Attorney General of the United States. We have rules here.
You're obsessed with him.
You're the Attorney General of the United States.
With obsessed with Donald Trump. You have Trump derangement syndrome.
Mr. Chairman, I'd like my time restored. I'd like my time restored.
In your district. In your district, and you don't even know about it, about keeping children safe from online predators.
Time belongs to the gentleman from Maryland. The gentleman can proceed.
Yeah, and if you go off on a wild goose chase, another tangent, you start reading statistics, or you start talking about stuff going on in our district, and by the way, I invite you to my district. Come to my district, but that's not what we're here to do today, okay? So, and you do that, then we're allowed to say we reclaim our time. At that point, you have to be quiet. You have no choice.
Rooms and committed sedition. Yet he didn't even know in your tiny little district who he was.
Mr. Chairman, she's embarrassing you.
He's about to be.
This is your committee, and she is embarrassing you.
Shame on you.
Thank you, Mr. Chairman. I want to start by saying I appreciate what you said, Attorney General Bondi, and you said it to me personally, that you take the personal security of every member of Congress seriously, and that people can contact you about that. And in these times, that's a very serious matter. So I thank you for that. Article 2, Section 1, Clause 7 of the Constitution is the Domestic Emoluments Clause. And it says that the president is limited to his salary in office and cannot receive any other money from the federal government while he's in office. It cannot be increased by $1. This president is the first president in U.S. history who has repeatedly sued the federal government for $230 million for the judicial search warrant at Mar-a-Lago, which was perfectly lawful and was never struck down. But now he's suing the IRS for $10 billion. He's suing the IRS for $10 billion, which I think is around 80% of its annual budget, because his tax returns were leaked. And they were illegally leaked by a private contractor who actually is in prison now, Charles Littlejohn. But he wants $10 billion. Now, well, I want to ask you the question of whether you think it would violate the Domestic Emoluments Clause for you to settle that $10 billion case or any of the other claims that the president has made against the government. He himself has remarked, it's interesting because I'm the one that makes the deal, right? And he says, I kind of have to work it out with myself. Do you think it would violate the Domestic Emoluments Clause for the president to work out a deal from people who are his subordinates under his unitary executive theory to get money in one of these cases?
I'm not going to discuss pending litigation.
Okay, so theoretically you're saying because his privacy rights were violated in that tax case, and they were. I'm with the president on that. I mean, his Mar-a-Lago thing is ridiculous, but there's no doubt that his tax returns, despite the fact that he promised to release them, despite the fact that every other president released the tax returns, he suffered embarrassment when it showed that he hadn't paid taxes for several years, and he had a right for that not to happen. Now, I want to turn back to the Epstein survivors, because President Trump may have been a little bit embarrassed by the release of those tax returns. How much do you think the claims of these survivors are worth? As the good congressman from Kentucky just pointed out, there were lots of survivors who had decided, for reasons of their own, never to release their names. That determination was represented to people in Congress, and we built it into our federal law that their names could not be released, and yet you published their names, their phone numbers, their addresses, personally identifying information. If Donald Trump can get $10 billion, theoretically, from the Department of Justice, how much should these people get for a far worse violation of their privacy rights and a far greater danger established to them in their lives?
Do you even know who Chase Mulligan is? You're so obsessed with, you don't, do you?
I'm going to teach you the rules again. You're the Attorney General of the United States. We have rules here.
You're obsessed with him.
You're the Attorney General of the United States.
With obsessed with Donald Trump. You have Trump derangement syndrome.
Mr. Chairman, I'd like my time restored. I'd like my time restored.
In your district.
Right here is where the exchange stops being procedural and turns into pure confrontation. Notice what just happened. Instead of addressing the substance, constitutional limits, the $10 billion lawsuit, or the survivor privacy issue, the response shifts into personal attacks and deflection. That's the pressure point. When a witness abandons direct answers and pivots to attacking the questioner, It signals that the line of questioning is landing. And Raskin recognizes it immediately. He doubles down on the rules, reclaims control, and forces the focus back to accountability. Ask yourself, if the answers were straightforward, why not just give them? This is the moment the hearing stops being about policy and becomes about credibility.
District in your district, and you don't even know about it, about keeping children safe from online predators.
Time belongs to the gentleman from Maryland. The gentleman can proceed.
Yeah, and I want the whole country to look at this, because this is the Attorney General of the United States, whose job is law enforcement. We've never had a witness who has misunderstood our rules and been unable to conform his or her conduct to our rules before. We have only 5 minutes, and so we use our time to ask you specific questions.
How long are you giving me to answer?
Excuse me, I'm not yielding to you right now. I'd like that second restored too. So, Ms. Bondi, the way it works is we ask you a question and you answer it. And if you go off on a wild goose chase, another tangent, you start reading statistics or you start talking about stuff going on in our district. And by the way, I invite you to my district. Come to my district, but that's not what we're here to do today. Okay, so, and you do that, then we're allowed to say we reclaim our time. At that point, you have to be quiet. You have no choice. You have to be quiet. So I hope you understand the rule at this point. Now, here's what I want to ask you. You're in law enforcement. We've seen all kinds of evidence of crimes. And when we go over to the Department of Justice for the 4 computers for every member of Congress, we see more evidence of crimes. Will you create a joint task force of the Department of Justice and governors and state attorney generals and district attorneys across the country to investigate the crimes that have taken place against these victims and more than 1,000 like them? The DOJ is not doing its job. Will you create a task force with state and local law enforcement to make that happen?
Gentlelady can respond if she wants to.
Thank you, Chairman. He called Chase Mulligan a wild goose chase and didn't even know who he was. He is a defendant in your own district who preyed on girls.
Mr. Chairman.
Well, you know what? If he were part of the Epstein investigation, you wouldn't do anything about it.
Online chat rooms and committed sextortion. Yet he didn't even know in your tiny little district who he was.
Mr. Chairman, she's embarrassing you.
He's about to be
This is your committee, and she is embarrassing you.
Shame on you.
The time of the gentleman has expired.
This entire exchange builds toward a very specific kind of exposure. Not a single gotcha moment, but a pattern. And that pattern is what makes this hearing so compelling to watch. From the beginning, Raskin sets a structured trap. He starts with respect, establishes common ground, and then methodically introduces a constitutional argument tied to a real-world action. The president suing his own government for billions. That's not just a political talking point. It's framed as a legal contradiction. Then comes the first key fracture. When asked a direct question about whether settling such a lawsuit would violate constitutional limits, the response is not a legal explanation, it's avoidance. I'm not going to discuss pending litigation. That might sound reasonable on the surface, but in context, it sidesteps the core issue entirely. The principle, not the case. And once that door opens, the rest of the exchange follows the same trajectory. What's especially revealing is how the conversation escalates when the topic shifts from abstract legal theory to human impact. The discussion of Epstein survivors changes the stakes instantly. Now it's not about billions or legal clauses. It's about real people whose private information was exposed. Raskin draws a sharp contrast. If financial embarrassment is valued in the billions, what is the value of actual harm and danger to individuals? That question lands hard because it forces a moral comparison that's difficult to deflect. And again, instead of a direct answer, we see a pivot, this time into personal attacks. That's the second major reveal. When a line of questioning produces deflection followed by escalation, it often indicates that the argument has moved into uncomfortable territory. Raskin doesn't chase the distraction. He tightens control, reasserts the rules, and brings the focus back. That's why the moment where he explains you have to be quiet isn't just procedural, it's symbolic. It's about who controls the narrative in a space designed for accountability. The final layer comes with the introduction of a local criminal case, Chase Mulligan. This is strategic. It shifts the discussion from national politics back to basic expectations of law enforcement: awareness, responsibility, and consistency. The implication is clear without being explicitly stated. If attention is focused upward on political narratives, what's being missed on the ground? By the end, what you're left with isn't a clean resolution, it's tension. A lawmaker insisting on direct answers, and an official repeatedly stepping around them. And that tension is the real takeaway. Because hearings like this aren't just about the answers given. They're about the answers avoided, the tone shifts, and the moments where control is contested. So the bigger question for viewers becomes, what matters more here, the technical defenses or the pattern of evasion under pressure? And when accountability mechanisms rely on structured questioning like this, are they actually producing clarity or just exposing how difficult it is to get it? If you found this breakdown useful, drop your take in the comments. What moment stood out to you the most? And don't forget to like, share, and subscribe for more sharp, no-nonsense political analysis.